this particular webinar. The audio and a link to the slides will also be available in the follow-up email you receive at the conclusion of today's webinar. Finally, questions. If you have questions, go ahead and type those in as we go. We should have plenty of time at the end to go over your questions. So now it is my pleasure to introduce our speaker, John Mondics. John is the president and founder of the Mondics Insurance Group based in Plano. Mondics Insurance Group was established in 1976 and is licensed in and serves commercial accounts across the United States. John has served on the board of directors of various insurance associations at both the state and local level. He has also served on advisory boards for some of the largest and highest rated insurance companies in the United States. And additionally, he serves as a trustee for a nonprofit organization that grants college scholarships to students based on need and qualifications. Mondics Insurance Group is a Texas REALTORS risk management partner and has worked with us in that capacity since 2014. John has also presented at our annual conference several times and has been a contributor to our magazine, Texas Realtor, on insurance-related topics. John, I'll turn it over to you. Thank you.
Thank you, Abby, and thank you everyone who signed on for this. This topic is going to be something that you're going to see debated both on the state and national level, not specifically maybe applying to realtors, but to independent contractors in general. As you can see by our first slide, the pain on this guy's face and where he is and the cell phone on the ground, he could very easily be a realtor that was out doing something in an office building and took this fall. So with that, let's get started, because looking at this guy grimacing, I think we all want to move on to something maybe a little more pleasant. So the first slide that I'm going to go to, if I can get this to go, Abby, and there we go. And that is, should I carry on-the-job injury coverage for my agents and employees? Well, you know, first of all, the good news is you don't have to in Texas. Texas is a state that does not mandate workers' compensation. We actually have a system in place where you can non-subscribe or opt out of the system, and we're the only state that has successfully done that. Oklahoma tried. It operated under non-subscription for a while and failed. Tennessee has tried. So we're very fortunate that we're here. So should you carry coverage? Well, as we've done in some past seminars, it's a risk management question. And like any risk management decision, you should evaluate the risk and decide to insure or not. Now, I talk to some people and they go, well, I self-insure that. And I want to touch on, don't confuse self-insurance and not buying insurance. Self-insurance involves a lot of quantitative analysis, predicting loss, funding for it, putting money aside, and truly self-insuring. And there are some companies that are big enough to do that. And in a manner, you can do that on a small amount, $1, $5, maybe $10,000. But when determining to carry coverage, what you have to do is weigh the potential loss to the cost of passing that exposure on to a third party, which is typically an insurance company. So simply to say, I'm going to self-insure without knowing what it would cost to insure is not the best practices. So let's talk a little bit about the typical losses. And I'm going to back up one here. The typical claims in automobile are auto accidents and slips and falls. You know better than I do that a realtor spends a lot of time in their car. And when they're in the car, they many times are looking at homes, neighborhood, comps in the area. And I could argue that this is a form of distracted driving. Maybe not as bad as texting and driving, but you are not focused on the road ahead of you, the traffic around you, pedestrians, etc., when you are driving through neighborhoods and doing any of the performance of what you do on a day-to-day basis. So there is potential for an automobile accident. The slip and falls, as the guy on the first slide was showing, that when you're out walking properties, you're walking into areas that you're not normally accustomed to. It could be stairways, it could be slippery floors, it could be properties that are in great condition, ready to show, others that are not in the best of shape, that need to have some work done on them before they're sold or they're selling as is. But no matter how you look at it, there is the potential for injury. And I think we both know that we see automobile accidents every day, and we probably have friends and business associates that have been involved in a slip and fall type downstairs or even on a slippery floor. So consider that any injury or loss will result in medical bills and loss of income. And those bills can be devastating. You know, you can make this as dramatic as you want with $1 million medical loss, medical bill, off work for a year or two. But for our consideration today, let's say that it's a $50,000 medical bill, which if you've had anybody go to an ER or something, it's pretty easy to rack up, and out of work for 6 months. You add all that together, you're talking about anywhere between $75,000 to $100,000 loss that there may not be coverage for. Sadly, that as we've dealt with the realtors on an intimate level over the past 5 years and got to know more and more about the profile, when we talk about the uninsured that are out there, that was a big focus on their Obamacare, we found that there's a lot of realtors who do, because they're not part of a large group, do not have any kind of group health insurance, and as a result are the uninsured. And so if they are injured, they may not have any kind of medical coverage in place. Also, one of the least purchased lines of coverage out there is a disability income. Very few people, other than under a big group program, or that maybe have a specific need, such as a career-ending disability for an architect or a professional athlete, buy disability income, loss of income. So if you're injured or sick, after a waiting period, it pays your lost wages. Well, when you buy on-the-job injury coverage, be it work comp or non-subscription, it includes those coverages. When somebody's injured on the job and they don't have health insurance, so they lose their income, sadly in today's society, they look for somebody that they can hold responsible for that, and sometimes that's the company that they're working for at that time. I'm going to briefly, well, a little more than briefly, but we're going to talk about independent contractor status versus employee. But when it comes to on-the-job injuries, that many times an injured party working on behalf of a company or an individual will try to pursue a claim against them when they're in that desperate corner and they need to find somebody to assist in paying their medical bills. So with that, let's kind of look around what's happening on a national basis, and especially as it applies to independent contractors. Like I said, we're in a good place in Texas today, but in the words of the famous philosopher Bob Dylan, the times, they are a-changing. So if you don't consider Bob Dylan a great philosopher or a great singer, that's okay too, but I like his quote. The Dynamex case, which if you've been following at all, has sent ripples through the independent contractor world. Dynamex is a motor carrier / courier company, actually based in Dallas, owned by a Canadian company that's publicly traded in Canada. And the Supreme Court ruling in favor of the independent contractors against Dynamex has made headlines, not just in insurance circles, but in all business circles that have independent contractors. Understand this will have impact on maybe realtors, barbers, beauticians, anybody that you think is traditionally thought as an independent contractor. Additionally, you look at Zip Realty and owners.com. Zip Realty is a horror story. Of course, it's in California. At one time, I think at one of the annual conferences, I made the joke that somebody brought up something about building the wall, and I said, we really need to build that wall on our western border because of all the influx of what's influencing us from California. This is one that is scary to everybody involved. Zip Realty had a complaint filed against them by 4 agents. They settled with them for $150,000 each for a total of $600,000. That's a lot of money into itself. But then the California Department of Labor came back to Zip and demanded an additional $9 million for what they deemed to be systematic violation of the independent contractor laws. Zip eventually settled for $5 million, but then had a second case that they settled in Arizona for $1.7 million. So you can see the seriousness and the amount of dollars that we're talking about. Owners.com also had a complaint filed against them, not quite as dramatic in the numbers, but these are 2 specific realtors that in California had these issues. And then we put Uber, the unintended consequences on all ICs. Uber has been the target of many lawsuits in multiple states, ranging from Alaska to California, to states in the Northeast to the Southeast. And when you look at the Uber model, when you first think about it, and you think who's an independent contractor, and we always would think about that an independent contractor would bring the tools of the trade, they'd be responsible for their own profit and loss, pay their expenses, everything that you deem as an IC. Some states have said, well, in this case, that's not right. We feel like that you exercise some control, you have some requirements, and they look back at everything from auto liability, when they report on, when they report off, and some control that may or may not be, in my mind, exercising control. But again, states all view this slightly different. So we have outside and within the real estate world, different independent contractor type businesses that will impact where we are today. So the ABC rule is what, to go back to Dynamex, that came back on them. And when you look at the ABC rule, and I've got those highlighted here, they say that you do not direct or control how a worker performs or accomplishes the work desired. The work performed is outside of the hiring entity's main business, such as an electrician or a plumber or somebody that comes to fix a light in your office. They're not your employee. The worker is customarily engaged in an independently established trade, occupation, or business. Well, you can look at 2 or 3, however you want to look at it, and see that the hiring entity, who is a broker, hiring a realtor, is in the same business. Bullet point 3 is they're customarily engaged. They engage established trade occupation of the business, which kind of saying the same thing a different way. But if you look at this ABC rule and you apply it to the real estate world, I think that we fail at least 1 and probably 2 of these rules. There's a conflict here because you do have a responsibility as a broker to supervise, to a certain extent, the people that are working for you. So what do? Well, again, we're lucky in Texas. We talked about that, and you can do several things. First of all, this is taking a step that says you want to provide some kind of protection for yourself in the event of an on-the-job injury. Still, you're going to make that determination, and you should follow best practices to try to keep these people that are working on your behalf not to be in an employee status. So this, by simply buying workers' compensation or non-subscription, the law is written in such a manner that it does not convert an independent contractor to an employee. Well, under work comp, it's pretty simple because you actually can add them by name to the policy by endorsement. Under non-subscription, you've got to be careful because a lot of those policies say employer, employee, and you have to manuscript that policy, change it. It says that these are not employers, employee, and coverage is extended to agents, independent contractors. So you want to make sure that everything you're doing is avoiding any documents that refer to employer-employee. Unfortunately, we're going to focus more on work comp because of the, believe it or not, at the end of the day, work comp on a real estate operation, especially brokerage, is probably going to end up being cheaper or the same price as non-subscription, and you get some benefits from it. So what's the difference? Well, work comp is a state-regulated system that covers medical bills, some lost wages, for employees that are injured on the job and can be extended to independent contractors. If you purchase work comp, Texas law limits the employer's liability for work-related injuries. So if you'll think of it almost as a not at fault type of system where somebody comes to work for you, you agree to pay their medical bills and their lost wages, and there's death benefits and ongoing that we could get into, but that's a long list of the benefits under work comp. But let's stay with the medical, disability, and death. Then they cannot sue you under the Texas Comp Act unless they can prove some type of negligence, more approaching gross negligence. So as long as you are not trying to do something intentional or willful, you have the protection of the Work Comp Act that if they try to bring that suit against you, it'll get thrown out. Now, again, if you can show that you were grossly negligent, that you put somebody out on a ledge that was about to break and they fell and you did it intentionally, et cetera, something way outside of the normal practices, they may be able to bring a suit against you. And there is some protection for you under the Comp Act, under what we'll talk about coverage B later. So what is non-subscription? Well, non-subscription in Texas, as we talked about earlier, you do not have to buy workers' compensation. And you're able to non-subscribe to the Act. So you say, I don't want to be covered under the Work Comp Act. I'm going to non-subscribe, and there is not mandated health insurance that accompanies that, but a better business practice is if you do non-subscribe, there are specific insurance products out there that will provide in a separate form coverage for on-the-job accidents. You do not want to look at it as an alternative. It's one is part of a law and one and has benefits, and the other is outside and has it. So you cannot look at it that I can substitute A for B or B for A. You have to take certain steps, and you get certain protection under comp that you will not get under non-subscription. But when you do it, you decline to participate in the comp system, and you typically purchase some type of accident health insurance that will cover the three primary issues that comp covers, and that's medical bills with an on-the-job accident, lost wages, and accidental death and dismemberment. And these have specific amounts. 100,000 death, maybe 300,000 death, medical bills of $1 million. You've got to watch these non-subscription. Understand that when you buy workers' compensation, except for the rates, and you can buy various deductibles, the benefits are all the same. Under non-subscription, these forms are filed, and they can vary from very limited coverage to very broad coverage. Some may exclude pre-existing conditions. Some may pick up pre-existing conditions. Some may pick up cumulative trauma. Some may have specific limits on hernias, things of this nature. They will have time limits on it. Understand that workers' compensation will pay medical bills until you have reached maximum medical improvement, and then at that point in time, there's some other steps that are taken. It'll pay disability income for a substantial period of time. So it goes on and on and on. Non-subscription typically will pay medical bills for maybe 2 years, maybe 5 years. Sometimes it'll extend to age 65. Sometimes it'll pay disability for a certain period of time. And then maybe you'll have long-term disability and temporary total disability. So when you buy a non-subscription policy, like you're supposed to do with every policy that you purchase, you really need to read the policy because there is substantial differences. All right. So the difference in coverage. I just highlighted many of those. There's many. We talked about if an injured worker can prove negligence on the part of the employer could be subject to damage awards, including punitive damages. Non-subscribers also lose 3 important common law defenses. These are really important. Okay, so when you buy comp, you don't lose any. You have actually protection of the Comp Act. When you don't purchase comp, you lose these common law defenses. Employees' negligence. So to use it in a manufacturing term, that if 2 people are working on an assembly line and I accidentally hit a button that injures my coworker, that's an employee's negligence. I can't use that as a defense as a non-subscriber. In the realtor world, if 2 realtors are riding in a car and the driver is involved in an at-fault accident and the other agent gets hurt, you can't use as your defense, hey, look, that was the other employee's fault, not mine. That employee's negligence is not a defense for you. We get into the fellow employee caused injury, and we just highlighted that. And the assumption of risk or danger. You can't say that they knew that was dangerous for the job or the task they were performing, and so they assumed the risk when they did it. This maybe does not apply in many instances to the real estate world, but it could if somebody went out to a construction site, happened to go up on scaffolding or do something, and they fell, even though your instructions told them not to do that. You can't say they assumed that risk and they did it, and so we're not responsible. You lose those common law defenses. So you can see, not just in benefits, but in protection under the Act, the Work Comp Act or not, there are some substantial differences on what you get and what you don't get. Okay, everybody, most people just think, I don't have to do anything. Well, you do have to do something. There is a form called the DWC Form 005. This form has to be filed if you do not have workers' compensation insurance or you've terminated your work comp coverage. However, if your employees are exempt from coverage under the Comp Act, domestic workers, certain farm and ranch workers, and you could argue maybe realtors on this, but again, if we're worried about the status of independent contractors to workers, or if you are going to employ somebody on a temporary basis, clerical help, property management, you could go on and on of the different things that you could be brought in and try to be deemed an employer, then you need to file a Form 005. Failure to file the form when required may subject the employer to administrative penalties. I get some pushback from people on this from time to time. First of all, there's no cost to do it. It's something that we're going to get into when you do it and how you do it. If it is there and you can simply file the form and have no chance of not being in compliance and have administrative penalties, why not do it? So, when do you file the form? Well, you're supposed to file the form annually, basically between February 1st and April 30th of each calendar year, or within 30 days of hiring your first employee. Unless this due date falls between the periods, then you must submit the form within that time period, or within 10 days of receiving a request from the DWC, Department of Workers' Compensation. So what does that mean? When would that third occurrence happen? Many times an injured employee will go to an attorney who will then go to the comp commission and say, does this company carry work comp or not? And if there's not, when you buy work comp, the company makes a filing on your behalf, evidencing coverage to the state, and then you post that you have it. So they're typically inquiring, we can't find any coverage. Can you tell us, do they have coverage in place? So important that you file this form. Here's a sample of it. By the way, I'm going to refer to a lot of forms. We showed this form, but there's a link that you can get on that once this is posted, that at TDI, Texas Department of Insurance, Texas, government forms, work comp, there's a substantial number of forms. They have these forms, I think, posted right now in English Spanish, and maybe Vietnamese. The law actually says that depending on your potential employee base, that you file it in languages that would apply to the people that you may be hiring or interviewing. So this form is quite simple. It's a statement. If you can read through it, it's really a name and address and that federal ID number. Not a whole lot to this. It's pretty simple to do. We have people that, while the form has changed a couple of times over the years, they simply keep their form and update it simply by inserting a new date on an annual basis, but it does make sure they're in compliance. Okay, do I have to file? How do I determine my filing start date and use May 1? Unless, if you've never filed this form, then the start date is first date you did not have coverage. So either 2 or 3 that the previous bullet points we went over. You terminate coverage, which if you have it now and you terminate it, then you probably are aware of a lot of this. Or again, you hired your first employee, then the start date is the first date that you did this. Again, the pushback is, why do I have to do it? Well, it's required. And secondly, since there is no cost to do it and it's an administrative function, we strongly recommend that you do it. Okay, do I have to file a notice of non-coverage? So you plan to purchase a work comp insurance policy, then end date is the last day you did not or will not have coverage. So if you decide to come in or come out, basically, you need to notify the department. Okay, how or when must a non-subscriber notify employees that work comp coverage is not provided? You must post a notice to employees concerning workers' compensation in Texas in the workplace in English, Spanish, and any other language common to the employer's employee population in the print type specified by the rules whenever you elect to not have work comp, cancel work comp, withdraw. Don't worry about being certified self-insured. Very few people are. You have to comply with certain financial requirements that I doubt if anyone on this call has that qualification, or have work comp coverage canceled by the insurance company. So what this is telling you that you must let, next slide, must let employees or even potential employees know that you do not carry work comp. So how or when must a non-subscriber notify employees that coverage is not provided? At the time of hire, when the employer elects not to have, so if you opt out, within 15 days of notification to the insurance carrier that you're terminating coverage, or 15 days when the insurance coverage is canceled by the insurance company. So before we get into the pricing, that the point is that while we can celebrate in Texas not having to carry comp, you still have to let employees and potential hires, and depending on how you want to treat agents that work for you, that you do not carry work comp. What it cleans up is by notifying them, posting a notice that, hey, I don't have comp, and it takes that question away. What some people have tried to perfect is that claiming they did not know and they made the assumption that work comp was in place when they went to work, and during the discovery and as the plaintiff's lawyers are pursuing the potential employer, they say, you don't carry comp, right? And the response is, no, I don't have to. Did you tell anybody you didn't have comp? Did you think enough about Susie or Bill, whoever it is, to let them know that there was no work comp in place? And then you get into the debate of, and it's not a comfortable position of, well, I don't carry it, I don't consider them employees or independent contractors. Did you know that you could, still apply coverage to them? Do you realize the cost of it and what occurred? So trying to come into compliance on this, and simply the notification will not cost you anything. And I think you're going to be surprised when we illustrate the few slides we're about to go through on the cost of work comp. So this slide is going to take you through the formula on how work comp is calculated. We took small. We took a real estate agency with us as the agent. These are dates. They're the current work comp rates. And the annual premium, with a lot of loads in here, and I'll explain to you what I mean by loads, totals $698 a year, and that's based on a $280,000 payroll we'll break down later. Understand that work comp is rated on a rate per $100 of payroll. So you normally estimate what your payroll is going to be for the next 12 months by the class code of business, and that's how you prepay your policy during the year. And if you're big enough, you can put on monthly reporting or a pay plan or whatever it may be, something like this to probably write a check for. And if your payroll were to double, then you're going to see, in this case, the premium would not double because the way the loads are done. But once we get big enough to eliminate some of the minimum premiums, you can calculate your premium yourself. So the next slide we have talks about the coverages. Earlier I talked about coverage A, coverage B, and there's actually coverage C, which is other states. That in here we're showing that we anticipate the coverage in Texas. I'll briefly talk about out-of-state coverage down under C. And it shows coverage A. Work comp, people say, well, I'm carrying $1 million for workers' compensation. Well, workers' compensation is a statutory benefit that the state annually looks at the benefit. Mainly, they look at the disability amount, sometimes tweak some other items, because medical has unlimited medical with comp, but they do change the potential maximum disability income that you can receive, and they review that annually and sometimes make changes, sometimes it remains the same. Typically, it goes up a little bit. So that's work comp. So your benefit on coverage A that you really rely on is a statutory benefit. Coverage B is employer's liability. Employer's liability, again, we got into the negligence, and it's typically illustrated with 3 different limits. We've increased this one to $1 million. Typically, they come at a $100,000 limit, and that is $1 million each accident, $1 million by disease, and $1 million by disease each employee. Coverage C is other states' coverage. Very interesting. One point that to consider is, since we are the only state that allows and recognizes non-subscription, realize that there is a hardline border around the state of Texas. If you non-subscribe, then coverage is limited within Texas. Now, understand that if you have a resident of Texas who travels outside, gets injured, then you're going to bring him back, and he's probably going to, he or she, seek medical care and rehab at home, and you're going to be able to have benefits under the non-subscription policy. But you get an employee or multiple employees, such as a car crash or multiple people seriously injured in a mandatory state that has work comp, and they decide to file for benefits in that state because they somehow determined that they're going to get better benefits and better care, and that state then reaches out to you and they try to determine that you had exposure in that state, you should have bought coverage in that state, then you may not have any benefit. We normally see this when somebody goes and works out of state for a temporary period of time, and they're in temporary quarters, such as, you know, a executive shared office suite, maybe working out of a hotel room on a project for 6 weeks or 2 months, and it could be deemed that you need to have work comp in that state. Well, so if you non-subscribe, then your non-subscription coverage is not going to apply in that state as a substitute or step in for workers' comp. Typically, we bring them back to the state and it's resolved, but there are some cases where it doesn't get resolved. So when you buy work comp, then you can buy other states' coverage except for these states, which are called monopolistic states, which basically have their own state pool, if you will. It's their own state program that injured employees participate in. So you buy Texas, you buy other states' coverage. So if you have a Texas-based employee that travels and they get hurt in another state and they opt for those benefits, then you have coverage. Understand under work comp that an injured employee can select one of three places. They can elect benefits in the state in which they reside, the state in which they were hired, or the state in which they were injured in. So they've got some flexibility. Most of the time, they bring it back to the home state. You can see where if there was a state that, like some states in the Northeast, that the weekly disability was substantially higher than Texas, they may opt to try to prove one of those up. For the most part, people come back to Texas and then we're okay. Okay, let's look at the cost of this. So far, I'm probably getting some people who are saying, oh, that's great, but I can't afford work comp. So what we did on this is we took a $250,000 in payroll for real estate agency, not clerical, but actually realtors, that they come in at an 8-cent rate. So on $250,000, that could be 5 people at $50,000. It could be 2 people at $125,000. You can bump this up 4 times to $1 million, and it'll be $800 in that. So you can see how this works. So it's an extremely inexpensive rate. Clerical, truly clerical means they're not there. They work behind a desk. That's somebody answering the phone, etc. So when you add those two together, you come to about $212. You add $3 when we increased our coverage B up, and so you're at roughly $215. Minimum difference. This insurance company has a minimum that you have to add $147 to get to the minimum premium. We went ahead and illustrated this simply to show that it has that minimum premium charge in it for the small realtors on the phone. Schedule modification was an 8% surcharge. This actually is saying, because it's such a small premium and no prior experience, this insurance company wanted to add 8% or $29 to it. But then they came back in, and much like many health insurance group policies, you can get into a healthcare network, a PPO, if you will, and for that you get a credit. In this case, they get 5% off or $20 off this premium. So the standard premium is $371, even given that $147. Another $260 is an expense constant that the insurance companies are able to charge, an expense constant, if you will, deem it administrative cost, whatever you want to, but that is where they throw in their expense constant for issuing the policy. The expense constant and the minimum difference, expense constant will remain the same as the premium goes up. The minimum difference will go down as the premium goes up because it's offset by additional premium. Terrorism coverage you probably see on many of your other insurance policies where you can opt in or opt out for terrorism. Some companies mandate it, don't allow you out of it. In this case, buying the terrorism coverage with everything we saw that's occurred with some of the horrific things in office towers and planes, etc., for $67 a year is probably not a bad idea. So the total on this is $698 a year. I mean, we're talking, $60 a month for everything that we talked about, the benefit that you can have, what can take place, and I don't want to downplay that roughly $700 is just throwaway money, but for the protection you get under the Comp Act for $700, I would do it. In fact, we did not illustrate the cost for non-subscription. I'll give you an idea. The non-subscription for a real estate office and clerical is probably going to be at or more than what the comp runs, because the minimum premiums, you're going to look at probably $40 to $45 per month per realtor. You can buy some deductibles and limited coverage and maybe get that down a little bit, but at the end of the day, if you buy it for $25 a month and you have 5 employees, you can see we're looking at over $100 a month or $1,200 a year. You can buy comp. Typically, non-subscription has a medical deductible and a waiting period to receive disability income. Work comp does not typically have a deductible, especially on this size premium. There is a waiting period on disability income, but which is typically you don't receive anything for the first week, but once somebody is off 2 weeks, then it goes retroactive to the first week. So basically it's eliminated. So why would you pay a higher premium to have a deductible and some waiting periods and not get the benefit of the compact when you could do something of this nature. So we have covered a whole lot of different items here, and I was trying to keep it within 45 minutes and pretty much dead on to where we got. So I think, in fact, I even suggested to Abby when she said, let's do a webinar, I said, I believe that this topic does better in a live seminar. But we talked about it and thought this would be a good start, because normally when we get these, and we've done them with the committee and in front of an audience, that you get the questions about maintenance workers, you get the question about part-time, you get the question about anything that y'all may have in your mind. So I'll open it up to Q&A, and Abby, it's over for however you want to do this.
Perfect. Yeah, we do have some questions. And again, if you have questions, type those in right now, and we will get to those questions. I'm seeing a couple questions about slides. We will post the slides. So visit our website, texasrealestate.com, our events page for webinars. You'll find the slides posted there, as well as a link to the recording. And then additionally, you'll receive a link to the recording and information about where to find the slides in your follow-up email. So check that out in case you want to review or missed anything. So we've gotten a few questions about the difference in lines of insurance, the difference between workers' compensation and, for instance, general liability insurance. Do you mind touching on the difference between the two briefly?
Sure. Yeah, and that's actually it's a good question, and it goes back to that early on we talked about risk management, and you never practice risk management in a vacuum with one line not applying to the others. Okay, so you have general liability. General liability, you typically think of, it's a third-party liability coverage, and it has an employee exclusion in it. So general liability would apply to, I'll use a couple examples. If you have an office and somebody comes in and they trip over a rug and they injure themselves and they sue you that it was your fault that they got injured, then you would have protection under your general liability for bodily injury if you're found that you are liable for that. You see this especially with if you have office buildings, shopping centers, sometimes developments, sometimes multifamily, that you own a piece of property and you rent it out to a tenant, and that tenant is injured and they come back and sue the property owner in general liability. That's where you find that coverage. Workers' compensation and non-subscription applies to employees. So, and independent contractors, they're excluded under GL, and third parties are not included under workers' comp.
Great. Another question, or a couple of questions that I'll try to kind of consolidate here, and it may be difficult to review this briefly, but folks are having questions about why this is important to consider for independent contractors, why workers' compensation is important to cover or to talk about with regard to independent contractors when they may not have employees. Can you touch on that briefly again? I know you spoke about that earlier.
Yeah, well, I think the exposure is there. You look at, and we touched on California and some of the cases that are out there, and the National Association of Realtors released a white paper on this about 3 or 4 years ago. And what we see is a movement both from different states, and we see some court rulings that have said, the lines are blurred between these independent contractors and employees. And so to protect yourself, that, first of all, make sure they are independent contractors, comply with everything you can in the state, and do the proper thing. But if you're able to take the premium that we saw here, and you have 2 realtors, and they're making $100,000 each, and you can buy that coverage, so if somebody does try to perfect that they are an employee and they are eligible for benefits, either way or not, when you add them to your policy and you pay the premium and they get injured on the job, That does not make them an employee. It makes you having protection under the compact. So the importance of it is that it's prevention, if you will, of what you're doing. And if nothing else, I would say that you put a form in front of them and say, hey, you know, you're an independent contractor, here's what I'm doing, and you post a notice if you don't buy work comp, that you don't carry the coverage, and the litigations we see going on today really requires you to almost view everything you do that you may end up having to defend that position, hopefully not sitting in a courtroom, but defending against allegations. So if you're able to prove up that, hey, I talked to this person, you know, I don't carry work comp, they know I didn't carry work comp, and then they got injured and now they're trying to pursue either an action against me, they knew I didn't have it. You can go so far as some employers who have a lot of employees have people sign off. They acknowledge there's no work comp in place. So it gives you that layer of protection for a very nominal premium.
Thank you. Here's another question. How will income replacement be done for agents who receive commission and not a consistent wage?
Yeah, typically the company looks back roughly, the insurance company will review past wages. Sometimes you'll hear people, they go back 26 weeks and look at that income. That many times we have to get that expanded and get people to work on it because the way that an agent is compensated varies. You know, you could have an agent that makes $250,000 a year, but they make it all at one time. So they'll get into consistency, what that pay trail looks like, and then work through it. If you have a person who in their whole career has only sold one deal and has never made another amount of income, then their lost income is going to be difficult to prove up. We do find adjusters that are receptive to working on trying to look at past wage earnings, but with a salesperson of any type, be it insurance, automobile, real estate, securities, whatever it is, wage determination that has spikes that are made all in one time and then drops, it is a difficult challenge, but we find the insurance companies to work and to be receptive to that. If somebody hadn't earned any income the past 2 years, they're probably not going to earn anything. There are some minimums that can apply, but we're going to have to see where they stand.
We've been getting a few questions about cost, pricing. So the first question I'll ask you is, how do costs compare, if you can answer this, how do costs compare across insurers?
Right. Well, work comp is, while there are filed rates, every insurance company can file different rates. They can take the base rate and they can apply their own schedule credits or debits to that. There's rate tiers that are out there that are, you know, plus percentages or minus percentages. When I look at this coverage, I think the worst thing you can do is to have your work comp with one facility, agent or company, your GL with another, your E&O with another, your auto with another, because again, we got to talk about the holistic view of risk management, that when you review insurance review, even for a small realtor, is time consuming. And when you're reviewing a separate insurance policy every quarter or every other month, then you're spending a lot of time and it's not a best practice. So you depend on, I would say you depend on your agent. The TAR is fortunate to have several good agents that participate within the association, and ask them for some guidance. So we know who's charging what rate, we know what's there. Now, some people get carried away with it. They want to go online and get 50 quotes on a $650 premium in an effort to save $50, and they pride themselves on doing it, and I get it. And they're welcome to go do it. Sometimes you got to just realize that there's more to buying that policy than the bottom line premium. Although I will tell you that a work comp policy is the the benefits that are under the policy are going to be very similar. The way the claims that are handled could be different. The way the billing's handled could be different. So I'd say rely on your insurance advisor or whoever that is to put you with a market and to get you competitive quotes. There's so many variances that you can do different things. Your payroll, if you go to the market and we quote you with a $250,000 payroll and somebody says, oh no, I think you got $500,000, and somebody else says 100,000, in your comparison, you need to make sure you have an apples to apples going across. But most agents, especially the guys that I see that I consider friendly competitors at TAR, are professionals, and they can guide you down that right path.
Great. Another question, again, about pricing. How does a broker's sponsored agent roster, meaning number of agents, impact pricing?
Well, it can. You're going to look, and since the best practice on this is to add, you have 4 agents, add them by name, you have 2, you add, you delete, whatever it is, and during that period of time, their payroll is going to be applied to the rate. So, you add 6 people, then you're going to add that premium. Some people get into back billing and doing some things with other independent contractors. I don't like that practice, especially when you look at the cost. I mean, the cost that you're looking at that we saw on $250,000, a couple of $100, you probably spend more giving them promotional materials out that are there, or coffee, or buying somebody lunch, or whatever you may do, than this. And at the end of the day, this benefit, workers' compensation, benefits both parties, but to the broker that does this, they get more protection from a catastrophic lawsuit, and the injured party is going to get benefit that if they are injured, the medical bills and the potential disability income, and potential death benefit, sadly, if something happens. And I think that some people were surprised at one of our risk management, or maybe more, committee meetings that I was talking to, that I expressed the 2 most potential areas that for injury are auto liability and what we're addressing today. And that we're not doing auto liability today, but an auto liability claim involving a third party, that we brought up GL, but somebody who is driving their personal car but on company business, and they can bring in the broker saying, you put them in that spot, now you're responsible. Those can be devastating. And that's why I don't like looking at any one line of coverage standalone without thinking of the other.
And I think we've got time for maybe one more question. Another question is the premium cost something that you can pass on to independent contractors?
My answer would be I do not recommend it, that I would check with your counsel on, do they think it's a good practice? I will tell you, in other businesses and other states, they do pass it through. But again, when you're talking about passing through a $4 or $5 a month premium, I think that it's penny wise and pound foolish. I think additionally that some people go, well, I'll do that and mark it up, which is strictly prohibited. Understand that insurance is a regulated line. So if you are passing through the cost and you get advice that that's okay to do, and some people will tell you that it might substantiate the independent contractor status when you make them pay for their own. I don't support that, but that doesn't mean that I'm right. That you must pass through the exact cost. So if that premium is $8 a month and you charge them $10 because, hey, I'm gonna round up, to whatever it is, then you have violated Texas Insurance Code, because you cannot mark up premium, then you are selling unauthorized insurance and it's probably not a good practice. Other people can argue that when you pass that cost through to them, you're somehow in the revenue stream of the insurance business and you should be licensed. And so there's a lot of that, pro and con of that, you can debate up and down. And if it was thousands of dollars, I think it would be good discussion. When you're talking about the premiums that we're talking about, I don't think it's advisable.
Understood. Well, thank you so much. I think on your next slide, you may have your contact information as well, in case we didn't get to your question today. But thank you so much, John. Wonderful information as always. I think this has been eye-opening for several folks too, understanding the risk that's involved. Before we conclude, I do want to remind everyone that the Texas Realtors Legal Series has 5 webinars each year. The next webinar that we have scheduled is for October 16th, and it will cover the legal issues surrounding surveillance. So be sure to tune in for details about that soon. Thank you again, John. We really enjoyed it. And until next time, everyone, thank you.
Thank you all. Bye-bye.